Hi, my name is Carl Pearson. I'm an attorney, and for the past 7 years I have been going into the New York courts to stop foreclosures and helping my clients get affordable loan modifications. There are 7 different points at which a loan modification may be granted to a homeowner. I want to discuss these points because a denial of a loan modification may only be the first of 7 different times you should consider making a loan modification application. I'm going to discuss New York law, which will be similar in the 23 judicial foreclosure states, other than New York's requirement that during court-sponsored mediation the parties are to negotiate loss mitigation possibilities in good faith. Let's get started. There's a lot to cover. You have to realize that for 99% of troubled homeowners, the only way to save their home is through an affordable loan modification. It's very unlikely that through litigation or inaction by the lender that they will be able to get title to their home free and clear of the present mortgage. It would take an entire different video to discuss free and clear and when it might occur. Accordingly, this video is going to just focus on how you go about getting a loan modification. Because most of the 7 points for obtaining a loan mod come after a foreclosure action has been commenced, it's important for the homeowner to retain a foreclosure defense attorney from the very beginning, even when you are considering whether to stop paying your mortgage and perhaps some or all of your credit cards and possible student loans. There are things a foreclosure defense attorney can do before any litigation starts that will help you get an affordable loan mod during the litigation, but I'm getting ahead of myself at this point. I'm going to assume at this point, at the very beginning, you have retained a foreclosure defense attorney to guide you throughout the process, and that is at the very beginning when you're first considering what to do when you realize you can't any longer afford to pay the mortgage. The attorney does not have to be licensed in your state and would be able to work with and through a licensed attorney in your state, which will make it far easier for you to obtain a local attorney after any foreclosure action is commenced against you. The first loan modification application, and that's before the foreclosure action is commenced in a judicial foreclosure state. The first thing to consider is whether you now qualify for a loan modification. This depends on the entity that owns or presumably owns your note and the type of government program available to you, with differences according to the size of the loan and whether the residential property is your home or an investment. Also, very importantly, is the length of time at which you're behind, because there comes a point at which nothing can save you if you're too far behind. They just can't issue a loan mod in most cases if you get too far behind, so be cautious of that and make sure that you're represented early in the game before you even go into default, which is the best thing. You and your lawyer need to discuss what you need to do to qualify for a loan modification, including debt reduction or elimination, proving income, and augmenting the income available for servicing of your loan. You probably need to overcome thoughts of a decreased credit rating to be able to save your home. Also, you want to determine if the lender or its servicer requires you to be in default before it will entertain a loan modification application. Some servicers require this and others do not. It's part of that dual-track fraud issue which you probably have read about. At this point, your lawyer can do some things for you before his or her presence is known to the bank to provide you with one or more defenses to a possible foreclosure action. So what I'm saying is that even before you get a notice that you should retain an attorney, you probably should retain an attorney and operate with that knowledge, but without the knowledge of the bank that you have somebody representing you at that point. This may encourage the bank or its servicer, and from now on I will refer to them as the servicer, to give you an affordable loan modification in order to end the foreclosure action. When the preliminary work is done without the servicer's awareness that you have a foreclosure defense attorney, you then should make application for a loan mod through an experienced loan processor who is being used by your attorney. This is a very important, absolutely critical, essential part of what you need to do. An experienced loan processor knows the rules and what you need to do, and equally important, knows when the servicer is making a mistake and what to do about the mistake. You may or may not get an affordable loan mod during your first loan modification application, but don't give up. You're only at the beginning. There is a lot more that needs to be done in order to save your home. The servicer may or may not offer you a loan modification, and if offered, it may or may not be affordable. But let's assume the worst, that you were not offered a loan modification, or one that was offered was not affordable. You are already in default, and the servicer is going to be replaced with a special servicer who is part of the securitization process to commence a foreclosure action against you and others occupying the mortgage premises, who are then called John Doe defendants, and others with a lien on the premises. The second loan modification application is at the start of the foreclosure action. Within 6 months or so of the time you stop paying your mortgage, a foreclosure action will be commenced against you by the special servicer or by the investor bank. In many or most states, including New York, the foreclosure action is put on hold while a mandatory mediation takes place called, quote, conferencing, unquote, under New York law. Although no litigation is permitted during the conferencing period, the homeowner is required to answer the summons and complaint on a timely basis, generally within 20 days of the service of the summons and complaint, but this can vary. Presumably, you already have an attorney who helped you with your first loan modification application, and now you need an attorney who practices law in your state to appear on your behalf in the foreclosure action. It is critical for obtaining a loan modification, an affordable one, that you defend the action timely with an appropriate answer with affirmative defenses and perhaps one or more counterclaims. This should be the only litigation cost you will incur during the second loan modification period, the conferencing period. Actually, you will be surprised to learn that there are no negotiations during conferencing, even though there is a duty under the New York law for the parties to, quote, negotiate in good faith under CPLR 3408F, which duty is enforced by the courts. You make your second loan modification application during this period, but this time directly to the servicer's attorneys, who submits it to the servicer for evaluation and then reports back to its attorneys, who then advises the court and the homeowner's attorney what the servicer has decided. If an affordable loan modification is offered and accepted, as it should ordinarily be, the lawsuit will be discontinued and the homeowner gets to keep his or her property with a interest and possible principal reduction in the payments that are to be made. On the other hand, if an affordable loan modification is not offered, this is not the end. There is more to come. The third loan modification application is to prevent a bad faith hearing. If an affordable loan modification is obtained during conferencing, you'll have no need of a bad faith hearing. But if no affordable loan modification agreement was offered, you may have grounds, especially if your attorney took the appropriate steps, both prior to the foreclosure action and when preparing the answer to the complaint, for requesting a bad faith hearing. This hearing should ordinarily be requested by letter or motion addressed to the referee in charge of your conferencing sessions, or to the assigned judge if any exists. The practice differs among the 62 counties in New York State. A bad faith hearing, when held, is a trial before the judge without a jury, in which the witnesses are sworn and testify and then are subject to cross-examination. Documents will be offered in evidence. The homeowner will try to prove during this, quote, evidentiary hearing, unquote, or trial, that the servicer, including the appropriate lender, if appropriate, failed to negotiate or act in good faith during conferencing as to any of the various loss mitigation options which are intended to either keep the homeowner in his property or lessen the economic impact to the owner if he is unable to obtain an affordable loan modification agreement and is required to leave the property. The various loan mitigation options are: 1, an affordable loan modification agreement; 2, a short sale where the lender accepts less than the amount owed and the homeowner is released from any liability for the deficiency; 3, a sale of the property at its present market value through listing and showing with any price in excess of the amount owed returned to the selling mortgager. And by the way, this is not often obtained but should be considered. Cash for keys or key money, often starting out at $3,000, to have you agree to move out within a short period of time, coupled with a deed in lieu of foreclosure and an agreement that you are not liable for any deficiency. 5, a deed in lieu of foreclosure with a lease from liability for any deficiency. And 6, a deed in lieu of foreclosure. It is interesting to note that this trial is held during a single morning or afternoon usually, and is not preceded with a costly and time-consuming exchange of witness lists, exhibits, exhibit lists, expert witness disclosures, proposed findings of fact and law, all of which would be quite costly for either side to prepare, which is a major benefit to the homeowner and his or her attorney. Any important part of this hearing is for the homeowner to request, when or shortly after seeking or obtaining the right to a hearing, limited discovery on the bad faith issues. You probably will want to avoid going into issues of, quote, standing, unquote, unless ownership of the note is relevant, such as in the case of ownership by Freddie Mac or Fannie Mae, who under HAMP, the Home Affordable Mortgage Program, are not required to consider a reduction in principal amount of the mortgage, whereas the other lenders and servicers subject to HAMP may be required to give a principal reduction if this is required to make the loan affordable. You will want to save your full discovery rights to later. During the preparation for the hearing, the servicer will try to seek permission to file a motion for summary judgment for foreclosure and sale, which needs to be resisted by the homeowner's attorney. When it dawns upon the servicer and its attorneys that there is going to be a trial in which the issue is going to be their wrongdoing, you can expect a more affordable loan modification offer to be made. This is the third loan modification possibility. One of the issues during this hearing should be based on loan modification proposals made by the homeowner, which he or she should be or would be willing to accept, and which the servicer will generally reject out of hand without consideration, which you would then argue was bad faith negotiations. But this is only one of various issues your attorney should be raising during the hearing. The letter or motion requesting the evidentiary hearing will generally disclose the grounds of the requested hearing, and the third loan modification possibility arises in an effort by the bank not to have any such hearing. The fourth loan modification possibility is during or immediately after the bad faith hearing. Assuming that the homeowner is not offered an affordable loan modification application prior to the scheduled bad faith hearing, the hearing will commence and be completed within 2 to 3 hours generally. And at the end of this period, prior to any decision by the judge, who will generally reserve decision and issue a written decision at a later date, which could be anywhere from 1 day to 6 months, but generally within 30 days or so, the servicer may decide to ward off the possibility of an adverse decision by offering an affordable loan modification agreement. This is the fourth loan mod opportunity. If you obtain a favorable decision, the judge may grant some form of relief or request a conference to discuss what type of relief is appropriate, which could be a dismissal of the foreclosure action, attorney's fees, or a monetary award of all interest sought by the servicer during the period that it acted in bad faith, or possibly some other or additional relief. The law is not well settled at this time, and any reasonable proposal will be considered. The court, however, cannot require the servicer or lender investor to enter into any affordable loan modification agreement. The threat of an adverse decision and the appropriate sanctions is the way of requiring the servicer to do what it really usually does not want to do, which is to grant an affordable loan modification agreement, which generally means tens or hundreds of thousands of dollars in overall relief to the homeowner, which is money lost to the lender investor. Assuming you are not able to get the judge to dismiss the foreclosure action and the sanctions imposed by the judge will act to reduce the amount of the judgment, the bank will then seek to proceed with its contemplated motion for, quote, an order of reference, unquote, and later with a motion, quote, for a judgment of foreclosure and sale, unquote. This starts the fifth loan modification agreement opportunity, and that's prior to or during discovery. You must remember that under New York law, there is no litigation allowed during the conferencing period, and the conferencing is how the lawsuit starts.